Thank you, Raymond, and thank you for Science Park in inviting me here to do a little bit of sharing with you on the intellectual property, particularly on IP, on patent here. I think what's my goal today here? I think many of you are, this is probably your first startup, right? And you may or may not have studied or learned anything on intellectual property protections or patent. So I hope that by the end of today, you would learn some basic stuff here, all right, in terms of when to use IP to protect your business. Okay? Right. Who recognize him? Okay. Right. Let me play a quick video here. Okay. So you guys all know him, eh? So you're not that young. Okay? Why did observe here? What are the IP here? Okay. Yeah, pay attention. What I want to show you. Okay. How did Michael Jackson make his money? Through entertainment, right? Through performance, right? Through singing, right? Through dancing, right? Okay, what is interesting about him? In this particular, this one is called Smooth Criminal. Okay, he actually invented something and had it patented. Okay. Okay, actually he received a patent from the US TPO, okay? This is called Antigravity shoe, okay? But did he make money from this patent? Obviously not. And just now you have heard from Ricky. He has been very successful, right? But he told you that he did not get his core technology patented, okay? So I'm gonna tell you about patent today. All right, you wonder, wow, why should I spend, next 30 minutes to learn about patent if patent does not guarantee me success? All right, so this is what I'm going to share with you. Okay, so a bit of my bio here. I work for Brand Lab, which is a Munich-based company. We are mainly in the neuro, spine, orthopedic, ENT surgery. All right, and we have a portfolio of subsidiaries in different areas. For example, this one is in a robotic, this one is imaging robotic, and then we have a couple of others that do medical big data, you see. So if your project are related to this area, feel free, contact me. I think I probably have a little bit more here that I can help you out with, all right? I'm a lawyer by training, okay? And what gave me the credential to speak to you here on the IP or on patent? Simply because I have an interest in this area. I've written something on Chinese intellectual property law, and LexisNexis had it published, all right? And it is available on a digital subscription, okay? And my current work mainly is involved in technology collaboration, all right? Investment, licensing, joint venture, okay? Yeah, and I have a lot of all these documents typically dealing with licensing, okay? Now, I'm going to cover a lot, okay, but it's just one slide, you see. So it's more like, all these, what are patent, who can patent, when to patent, this kind of things. Very basic stuff, you see. So I hope that you learn something today, all right? Now, what makes up intellectual property? 4, trademark, patent, copyright, and trade secrets, okay? Now, what are they? Right? We go slightly deeper, okay? Trademark, basically you associate with logo, okay? Design, external appearance of something. In certain country, we call it registered design. In certain country, we call it design patent, okay? Now, copyright, you probably know, all right? What you have just watched, that is a copyright by Michael Jackson, okay? Patent, now patent here, it's quite confusing because different countries sometimes call it differently. In China, we call it invention patent. This is the patent of, highest quality, you see, all right? Utility model patent, UMP in short, it is what we sometimes call mini patent. It's a slightly of a lower quality, okay? Now, another one is trade secret, like, the formula behind Coca-Cola, all right? Nobody knows what exactly that is, okay? Now, what is this? Who can tell me? We are in medtech, right? In life sciences, right? Do you know what product, what technology are this? Surgical robotic, that's correct, okay? Now, what comes to your mind, okay? There are so many IP surrounding this, okay? I'm using it as an example here. Trademark, you probably heard of Da Vinci, Intuitive Surgical, for example, all right? And a few others, Marco Mazzo, Cirque from my company, you see, for example, okay? Now, what about the patent here? All right, actually, there are many, many patents in these products, okay? It could be invention patent, it could be UMP here, and you dissect it, you see, you understand. It could be robotic system, force contact feedback, surgical navigation, human-computer interaction, and so forth, you see. There are many, many, all right? So if you invent something, does not mean that you're gonna have, the complete patent over the product. Maybe some patents are owned by others, remember this, okay? Design could be the external appearance of the robotic, all right? Copyright, mostly are software these days. And trade secret, you don't tell people your secret sauce, okay? Now, what patent can do? Okay, Ricky can be successful without patent. But look at this. You know what patent is this? Too small, right? It's called a method for node ranking in a linked database. Never mind. Look at the picture, you know him. Okay, and without this patent, do you think he's able to raise money? Okay, maybe not, maybe yes, we do not know. Maybe he may not be as successful. Right, certainly patent help, okay? And especially for startup, you see, if you want to raise money. I think I overheard that Ricky was having a challenge to raise money, right? So, maybe you need patent, all right, to go out and tell people, look, I really have something, you see. Believe in me, you can put in your money into my company. Now, why is that a patent? Very simple. For the inventor here is to give you some kind of exclusivity. Sometimes we use the word monopoly, which is not very accurate, all right? But we will say it's like a limited exclusivity for a period of time for you to enjoy your invention, okay, in short, okay? And you can stop others from exploiting your invention. For society, why they agree to let you have this so-called exclusivity? It's simply because you're gonna promote innovation through technology, knowledge spillover, all right? And eventually it promotes innovation, all right? And leads to economic success. So that are the philosophy behind intellectual property law. Now, I'm showing you this slide. Actually, I taken from one of our mentors. You see. He attended I think it was a pitch, you see, where people were pitching for being who has a better idea and so forth, you see. So I think these two are from Hong Kong U, you see, and they have a long IP portfolio, okay? And you can see, all right? China patent, Taiwan patent, PCT, Hong Kong US patent, all right? It's all over fecal bacterial marker for colorectal cancer, all right? Why I'm showing you this? Simply because one invention, you can get many, many patents in different countries, all right? Okay, I'm going to come back to this. Now, what is patent? Okay, I'm going to emphasize here. It's an exclusive right. Does it mean that you have monopoly? No. What it meant is that you can stop other people from using your invention. Okay? Now, it could be a product, it could be a process, but it must be something that is new. It's a new way, as a technical solution to solve a problem. So that is the gist of it. Okay? Any country that you go, basically this is the gist of it, okay? Now the second point here is that once your invention is patented, it cannot be commercially made, used, distributed, imported, or sold by any other people without your consent, okay? Now, I bring you back to the slide I showed you on the robotic system, okay? What if one of the patent is owned by others? They can stop you, okay? So you don't get that monopoly, you see, because someone owns it. So basically, you have to make a deal with the other person, okay? Can you license it to me, allow me to use in my invention? You probably will have to do such a deal, okay? Now, I continue, okay? I spoke about this earlier on. To get a patent, basically, the society required you to disclose your secret sauce. You have to share the knowledge behind your invention, all right, so that other people can learn from it and build something on it, okay? Now, patents are territorial. Remember I was showing Taiwan patent, Chinese patent, Hong Kong patent, and whatnot patent, all right? What it means is this. If you got a patent in Hong Kong law protects you. Macau doesn't care, Taiwan doesn't care, mainland doesn't care, all right? If you have US patent, very good. China doesn't care, Japan doesn't care, all right? So to protect your invention, you actually have to get a patent granted in all the different countries. That's the meaning of territorial, okay? Now, another point here is that patents are different from country to country, right? But actually, I use the word territory, right? Macau, Taiwan, Hong Kong are territory. They are all different, okay? But the law are basically quite similar, broadly similar, okay? With slight variation, okay? Now, another principle that is important to remember is first to file, okay? Of course, you got a choice that you don't have to file a patent, okay? You keep it as a trade secret, all right? But what if someone else accidentally come up with the same idea, same invention, they file the patent first, and then you will be prevented from exploiting your invention already, all right? Whoever file first, who get it first, okay? There are different types of patents I've shown you earlier on. The last point here is that there is something people always confuse. I got an American provisional patent. Is that a patent? The answer is no. That is not a patent, okay? So we need to be very careful. Filing an application, all right, it gives you certain protection, but it's not a full protection. The full protection comes in only when your patent is granted. Okay, bear that in mind. Okay, why do you patent? Okay, IP patent is a class of asset. Okay, you can use it to raise money. All right, you can make money through commercialization or through licensing. Okay, it increases your company valuation. Okay, you can also stop your competitor from using your invention. Now, in situation like the example that I give you, the surgical robotic, you probably have to do some sort of cross-licensing, you see. I license part of mine to you, you license part of it to me. Otherwise, you cannot sell yours, I cannot sell mine, you see. It could be that kind of situation. All right, in medtech, it's not that prevalent, but in telecommunication, it's very common. Huawei, Apple, Samsung, and all that, you see, they do a lot of this cross-licensing, okay? Yep. The other one is to leverage against competitor. If your competitor suing you, you can counter sue them. You see, look, you say I infringe yours, you also infringe mine. Okay? So it's more like a defending, you see, defending yourself against a competitor. All right? And last one, I think, assuming that you have got your publication, you have got your patent, you go out and talk to an investor, right? It increase your so-called credential, isn't it? Okay, right? And then of course it could be also for vanity purposes. All right, you get it for the sake of getting it, just to show off. Your resume looks better. You see, all right? Because most of the patents in the world are not commercially exploited. Okay. Now, why don't you patent? Okay, ask yourself: can your invention be protected in the form of trade secret? So you don't have to file patent, you don't have to pay money, all right, to maintain your patent, okay? Now, especially if your invention is difficult to be reverse engineered, okay, then yes, you could do it. But if it's like an instrument, people can look at it, you see, they can reverse engineer it. Sorry, that is not a good idea, okay? Another example would be, what if I don't protect it in the form of a patent? What if it is in copyright or in the form of trademark? Would it work? Okay? But I would say for our medical technology, chances are you will try to protect it in the form of either patent or copyright. Trademark is not that powerful unless you are in a consumer product category, okay? Now, what if your invention is life cycle is very short? Okay, probably it doesn't make sense. Like the COVID-19 rapid test, for example. Why Ricky, I speculate, okay, why he did not patent it? Because patent would take like 2-3 years. Okay, it just does not make sense. You just got to seize that opportunity, and make profit, you see. Go for it quickly. Okay. Now, other consideration is that I told you patents are territorial, right? So the total cost of the patenting can be very huge amount of money. Okay, especially if you were to file patent in USA or trying to enforce your patent in USA. Okay, that is going to be a lot of money. All right, unlike say mainland China, for example, you see, it's a different story. Okay. Now, another point is that a lot of people have forgotten. Okay, you thought that I file a patent and I will for sure get a patent granted. Not true. Okay, the ratio is about 50 to 60%. All right, of success. Many of them fail. All right, so you have to consider. You see, what if people challenge your patent application, okay, or trying to invalidate your patent? Now, this is a study done in America, published in year 2000. They give you the reason why they are doing patenting. Okay? I assume that in the last 20 years, particularly in medtech, in life sciences, the reason will be licensing revenue would have gone up, you see. This one is done across multiple industry. Okay? Now, what cannot be patented? Okay? There are quite a lot of things that cannot be patented. All right? When you look at the law, right, wow. The one that I bolded, method for diagnosis or treatment of diseases cannot be patented. Uh-oh. So you're wasting your time here, right? Okay. Don't worry, okay? Basically, I make it in very simple layman terms is that if you are trying to file a patent directly, you see, to protect a method for diagnosis or treatment of diseases, you will fail. All right, but you reframe it slightly differently that you are patenting an instrument or a substance, okay, all right, for the diagnosis and treatment of diseases, you are likely to be successful. So don't worry about that, okay? Patent law does protect your work. That's my point. Now, okay, this one is specific to China, okay? What's the difference here? Mainly is an invention patent give you 20 years of protection. UMP and design patent give you 10 years. All right? That is the main difference. Procedurally, okay, invention patent give you 20 years and therefore it required more steps. All right? Essentially, there will be 5 steps here, okay, from the moment you apply. All right? Okay, then there is a preliminary examination, publication, substantive examination before the grant. In China, it would take between 2 to 3 years, sometimes slightly over, before a patent is granted. Okay? Now, what it meant is this. The grant could be 3 years. Let's say now it's 2021. You get your patent in 2024. Okay? When does the patent start running? It starts running from the day when you file it. All right? Okay? That's important for you to know. Another one is that publication is, you have to disclose your secret source. All right? You have up to 18 months. All right, to keep your secret source secret, okay? Now, UMP and design patent, 3 steps. There is no substantive examination. Basically, the examiner is going to look at your application and the document and make a decision, all right? So a lot of people favor this because it's quick and easy, okay? But that also means it's easily challenged as well, all right? Someone, your competitor, could always challenge and invalidate your patent. Okay, so the failure rate of UMP is greater than an invention patent. All right, you see, you can get it done in, say, UMP is like, in a year you can get it done. All right, so it's very much favored, you see. And a lot of startup in China, what we see is this: they will file a lot of UMP. All right, because, unless you are someone who are in the industry, all right, or you are working in venture capital and all that, you understand the difference. But other people would not know, okay? You can go out and say that I have 50 patents. Wow, that's impressive, right? Okay, conditions. I wouldn't go into, it is a complex area of law here. Essentially what you need to know is that for you to be granted a patent, your invention has to be new, that is novelty, all right? Inventive, creative, okay? Now, in America, normally they use this standard. They call whether it's non-obvious, okay? All right? And the third one, whether it's practical or not. Practical does not mean that it has to be commercialized. As I told you already, most of the patent had never been commercially exploited at all, all right? What it means simply is that as long as it can be reproduced, okay, it's considered practical already, okay? Now, who can file patent? It could be any individual, you know, local, citizen, non-citizen, okay? No problem. Now, when to file patent? This is important, okay? Especially, you know, you guys are fresh from the university, you see, many of you, all right? The truth is this, all right? For your invention to be patented, it must not be disclosed beforehand, okay? If you disclose to the world, I'm sorry, okay? You can't patent it, all right? So what is the ideal time for you to file a patent? It will be before public disclosure and when your invention is about to go to the market so that you can take advantage of the protection, whether it's 10 years or 20 years, all right? So as a startup, in your case, you are likely to file it earlier, okay? The reason is this, because you want to go out to talk to your investor, for example, all right? To impress, you know, some of your supplier or even your customers, okay? You file earlier, okay? But if it's a big company, they tend to file it later on, all right? Because they want to take advantage of the longer term of protection. So that is the difference, okay? Now, where to file, all right? This is a big question. Should I file in Macau, Philippines, Cambodia? Maybe not, all right? Consider this. Where are your market? All right? So very often when you do a market sizing, right, you only consider Hong Kong. Is Hong Kong big enough? Okay, you have to consider, you see. I would suggest that you look at a global market size and at least the China market size or greater China market size, right, in order to be relevant here. Consider also where your product eventually is going to be made, all right? Okay, where is your competitor's location? Where are you likely to enforce or sue someone if they infringe your patent, okay? Now, the answer is this, in my opinion, all right? You are likely to file your patent in this, 5 to 6 patent offices. China, CNIPA, all right? USA. WIPO is not really, okay, but there is a process there. I will explain it to you later on. EPO, all right? Quite similar to WIPO, okay? There is no European patent, by the way, because Europe is not a country, remember? Okay, I'll come to that later on. Japan. Hong Kong, you will do it because you are probably getting a government grant or government subsidy, you see, so you will do it here, okay? Okay, why file patent in China? China has been the world-leading country in terms of, patent application, you see, for the last, I think, almost 10 years now, all right? That is in million, 3.2 million in patent. China, like 43%. Do you see that? Okay, why? Okay, because there had been a lot dramatic reform in China, particularly in the area of IP. Let me go through it quickly. Why Chinese want to protect IP? Because of their own innovation. Their domestic sector is putting pressure, all right, to have better IP protection. So pressure is not coming from a USA anymore, okay? Now, so what happened is that I'm just taking some example from the more recent years, you see, all right? You can see there are so frequent are the amendments to the IP law in China. Trademark, all right, civil code patent law, you see, all done very recently, all right? Administrative reform, okay? They consolidate and put it under this body called CNIPA, Chinese National IP Administration, okay? Very recently. Court. At the Supreme Court, the highest court level in China today, there is a special division called Supreme People's IP Court that deal with IP cases. Why? Okay, before I go talk about that, they are specialist IP court, just deal with IP cases, all right? Other countries have it too, okay, nothing special. All right, what is special here is this, there's IP court at the Supreme People's Court level since 2019. Look at the number of the IP litigation, almost 500,000 cases. All right? Okay, that's a lot, isn't it? Okay? So I'll skip that. Now, just now I was showing you WIPO, right? WIPO, remember that? you probably will have heard of PCT, okay, filing, Patent Cooperation Treaty. All right, there is one advantage you want to file under the Patent Cooperation Treaty. China, Hong Kong are member of this treaty. It gives you an advantage. All right, it gives you an up to 30 months for you to decide which country to file. Okay, so let's say on day one you file in Hong Kong or in China, let's say. All right, through this process you can wait until 30 months before you decide whether should I do it in India, all right, in Japan or in Singapore or whatever. All right, so that is the beauty of this PCT. Okay. Okay, what to avoid? Okay, we have heard. Okay, a lot of innovation fail to make money. Okay, some examples are given to you later on. For example, some of them they're simply doing it for, maybe very noble intention. You see, all right. Like the Japanese guy who invented karaoke, he did not get it patented. So when you sing karaoke, right, he did not get a cent. All right, that's example. Or in our medtech sector, the best example is CT scanner. The guy who invented CT scanner, all right, Hansfeld, he won a Nobel Prize. All right, but the company that he worked for, EMI Lab, failed to take CT scanner. Actually, it was wound up, you see, and the business has to be sold to someone else. All right, so there are certain things that you need to avoid. Of course, there is a lot of other things, you see. All right, like, do you have the complementary asset in manufacturing, or do you have the clinical network, you see, to do trial, that kind of thing, you see. All right, because your products are likely to be regulated, right? Okay, so you need to have other so-called complementary asset in order to make profit through your innovation, okay? The last one is you need to follow through, all right? Grant rate in patent application is anywhere between 45 to 60%. China is 47% last year, okay? Meaning out of 100, only 47 succeeded, okay? USA slightly better, I think somewhere close to 60%, okay? That means you need to work very closely with your patent agent or attorney, okay, in order to secure the patent. Now, okay, I will wrap up here. Okay, what will be a practical advice here? All right, unless you are in a situations like, this very exceptional COVID-19, you see, you develop a rapid test, all right, you can ignore patenting, all right, go straight to the market, okay, like Ricky. But in a normal time, okay, you probably would have to consider IP protection. And the earlier it is, the better for you, all right? American have done studies here, all right? They look at, thousands of startups, you see, right? And they're looking at the most successful company are those who have initiated IP protection when it is still very young, all right? Now, patent search, very simple. You can use the Google patent search, all right? Okay, and you can see whether there is any other conflicting patent, all right, against your own invention, all right? You can do some very basic due diligence at the initial stage without costing any money, okay? File before any disclosure or publicity. Now, this is very important, yeah? I'm going to lead to this point. And here, I took it down from my back, you see. All these are NDA, non-disclosure agreement, all right? In our line of business here, okay, you want to make sure that people sign NDA before you talk to other people, okay? Now, other than that is non-compete agreement. What if, let's say there are 3 of you working in a team. Have you signed a non-compete agreement? Otherwise, each of you can claim that you contributed to the invention, you see, and each of you decided to go on your own way, okay? True? So basically, you should have a deal among yourself. We would not be competing among ourselves. Let's sign a non-compete, okay? Now, what if now you need to expand your R&D team, okay? You need to hire people now, all right? And you have to disclose your secret sauce because you want them to work on it, right? What do? You, in your employment agreement, you have to get this, what we call independent contractor clause into the agreement, you see, right? So basically, the ultimate invention based on your secret sauce, okay, will be assigned to you as the owner, okay? So these are some of the legal issues that you need to consider, all right? Other than that, I would say apply for government money, okay? I think Hong Kong Productivity Council They have such a scheme too, okay? All right. And fall in the market with commercial potential. I already shown you in the earlier slide. Those are your market, all right? You will not be considering, Indonesia, Malaysia, you see, all right, for your product at this stage, I think, okay? All right. And the last point is this. It's not that easy for you to go all the way to commercialize it. It's a long, long journey, okay? And you got an option here to license it, all right, to someone who is already established. And they got a deep pocket to pay you, okay? All right, and you can do some kind of technology transfer as well. All right, and at this stage, I can tell you, because I work in this area, okay? Currently in China, there are just so many opportunities, all right, looking for technology transfer. You have something sexy and exciting, all right? All you need to put in is your technology. They will come up with the money, okay? All right, just a quick one here before I hand it over to the next speaker, all right? The difference between the Chinese patent and US patent system. Now, the first thing to remember here, invention patent is the word used in China, but over in USA it's called utility patent, okay? But don't confuse this utility patent with a utility model patent, all right? So I want to highlight this difference. They are broadly similar, okay? I think I have missed something. I want to tell you something. Generally, invention patent is 20 years, okay? But if you are developing a drug, okay, a drug patent can be extended to 25 years, all right? The Chinese law, recently amended, will guarantee you that you will have a maximum of 14 years to commercially exploiting your patent. Why? You know for drug, right? You need to go through so many clinical trials and then eventually get your approval, all right? So that they want to give you a reasonable amount of time for you to enjoy your invention. Okay, but all other patent is 20 years. Now, design patent, okay, same, but the time is different. Do you see it? Okay, and in USA, there is no UMP, all right? But China has this express patent that you can get it done quickly. And the last one is, USA has a provisional patent, but China does not have one, all right? And as I told you earlier on, provisional patent is not a patent, okay? It just gives you an option within 12 months to decide whether or not to file a patent in USA. Okay? So don't confuse. Provisional patent just gives you time up to 12 months to decide whether or not you want to file patent in USA. All right? So nothing is secured. Okay? Okay, that's all. All right? 30 minutes. Raymond.
My name is Robert Jackson. I am a patent attorney, U.S. patent attorney. I've been practicing for well over 10 years now. I started my career as a synthetic organic chemist. I worked at 2 different startup companies before transitioning into a legal role, and started my current career as a patent attorney. I've been practicing now in Hong Kong for close to 5 years. Most of my clients are universities, government research institutes, small to medium-sized enterprises. My practice focuses primarily on pharmaceuticals, chemical life science related inventions. And so today, what I'd like to talk about is I'd like to provide a little bit of context and some framing to the very good overview that Mr. K.Y. Tan provided to the patent system. And these issues that I'm going to be sharing with you today are issues that frequently come up with my clients, particularly startup companies or clients that are filing their first patent application. So I think it's really, really important to provide some context to the patent process. And impress upon you that this is not merely a box to check. So switching to the next slide, here we are. Let me move this out of the way. So today I'm going to briefly reinforce the importance of patent protection, particularly for startup companies, chemical life science startup companies. And then we're going to spend a little bit of time talking about the patent filing timeline as well as the budget. And then touch on some of the benefits that the PCT system can provide to cash-strapped companies. We will then revisit the patent, some of the patent requirements, and discuss the importance of doing the required research to support the patent filing, and show how the data that goes into the application, the data that goes into an application, can support the patentability of the invention. Then I'll provide an overview of the patent preparation and examination process, and again, emphasize inventor involvement. It's very important. And then lastly, I'm going to touch on freedom to operate, which is the opposite side of the coin that we've been discussing thus far, which is patentability. And then if we have time for questions, I'm happy to answer any questions you may have. All right, so Mr. Tan already talked about the importance of patent protection, but what I want to reinforce here is that for chemical life science companies, because of the huge amount of money that's spent on R&D costs, up to 50% of expenses, patents become very, very important in protecting those investments. So for many small startup companies, as has been mentioned before, they may not directly market their products. In many cases, they enter into agreements with larger companies or out-license their IP, or their exit may involve being sold off, but being acquired by a larger company. And so it's important to note that at these early stages, that the IP that's being generated by the company is its most valuable asset, and is the product that's being generated. You take that coupled with the fact that the product cycle, the development cycle for pharma and biotech products and services tends to be on the order of decades, 10 to 20 years, as opposed to software or something in the high tech where maybe the development cycle may be measured on the order of days. That reinforces the importance of investing investments into R&D to ensure that there's a return on investment later on once that product hits the market. And so IP is said to be at the core of the business of biotechnology companies. It strengthens its market position and increases the valuation of the company. So IP should be at the forefront of your thinking when developing products and services in this area. So this timeline is going to look a little bit familiar. We saw something similar to this in Mr. Tan's presentation, but I've included additional some more information here just to provide a little bit of context and discuss the actual work involved in preparing and filing a patent application. So what's shown here are two different pathways for filing a patent application. On the top here is a PCT application, and on the bottom here, these are direct filing applications. Both of these routes, there are many ways to file your patent applications, and the strategies involved for filing patent applications will involve a number of considerations, and I've just mapped out a couple here. So in this case here, at month 0, we would file a priority application. That can be a US provisional application, that can be a Hong Kong original grant patent application, that can be a China patent application. But what's important here is that this filing date determines all downstream deadlines as well as costs that are generated at various dates here. So let's just take, for example, filing a US provisional application. There are fewer formal requirements for a US provisional application. They are not examined by the patent office and merely serve as basically a timestamp. It affords a filing date for the invention described in the application. And the filing date is very important because it determines what is prior art, everything before that date, and what is not prior art, everything after that date, with respect to what's described in the provisional application. Because there are very few formal requirements for filing a provisional application, many of our clients that are working on very tight budgets may file a scientific publication or prepare something themselves without involving an attorney and file the application. The application fee for filing a US provisional application for a small entity, a startup company, let's say, 150 US dollars, or about 1,200 Hong Kong dollars. The fees increase, obviously, if you involve a patent attorney. There's also an option to fully draft the US provisional application, and this is something that we recommend because it provides a broader and more detailed description of the invention, and that becomes important later on, potentially, for establishing the novelty and the inventive step of the invention. So at month 0, this provisional application is filed, and you then have 12 months to file a non-provisional application. That can be a PCT application, or it can be direct national filings that claim priority back to this filing date. And by claiming priority, these applications, either the PCT or the direct national phase applications, will be treated as having been filed on this date under the Paris Convention for the information described in the provisional application. At this stage, whether it be PCT or direct national phase applications, there are more formal requirements that need to be satisfied by the applicant. So very often, companies will engage a patent attorney at this stage to help with drafting the patent application to ensure that the invention is properly described and claimed. So this can involve costs of anywhere between 45,000 Hong Kong dollars up to 120,000 Hong Kong dollars for filing, drafting and filing either a U.S. national patent application or a PCT patent application. For multidisciplinary inventions, like anything involving AI and biotech, combining the two, in those cases, the expenses can be even higher because of the complexity of the invention and the extra effort required for drafting the application. What I want to emphasize during this period here is that the applicants are offered are given about a year to do additional research to further support the filing of their non-provisional filing, their PCT or their direct national phase applications. And it's very, very important that this additional research, if necessary, is completed to support the patentability of the claimed invention. And I'll talk a little bit about why that's important in later slides. It usually takes us about 4 to 6 weeks to draft and file a PCT application and a direct national phase application. So you want to allot that amount of time in order to prepare the patent application and file it. You want it to be well considered by both the inventors and the patent attorneys before filing. And so what this means is you can't wait until the last minute, for example, before a big disclosure, a public disclosure, which would affect the patentability of the invention, to begin drafting the application. And the same is true of the provisional filing. Work for the provisional filing and the PCT or the direct national phase filings actually begin well before these filing deadlines. And so I would encourage everybody to begin thinking about preparing the patent application, collecting the data, and engaging a patent attorney to draft the application, permit time for the inventors to review the draft application, and then finalize it so that both the inventors and the patent attorney are on the same page when filing the invention. So the PCT application is filed at month number 12, and at 16 months, if we go down the PCT track, it will give the applicant a first look at what a patent office thinks of the invention. So an international search report will be issued to the applicant, and at this stage it's confidential, and it will provide an evaluation of the invention with regards to the novelty, to the inventive step, enablement, written description, all of the requirements for obtaining a patent here at this stage. And so there is an opportunity for applicants to respond to the international search report and written opinion, or not. If it's positive, then there's probably no need to respond to the international search report and written opinion. But some clients do decide to respond to it. At 18 months, for the PCT application, as well as any direct national applications, the application will publish to the world, and everybody will find out exactly what you've been up to. So at this date, 18 months, your PCT or your direct national phase application will publish. But not only that, the public will have access to your provisional filing as well. So the contents of the provisional application also become public at that stage. 12 months down the line from the publication of the PCT application is the national phase deadline for most countries. Most countries have a 30-month national phase deadlines, but some countries have 31 months or 32-month deadlines for filing national phase. And this is where costs really balloon, because now we're talking about translating the PCT application into the various languages that the national phase applications will be examined in, as well as paying official fees for filing and attorney fees for translation and filing. And so costs really rack up here. So we're talking about anywhere between 40,000 and 100,000 Hong Kong dollars per country just to file the application in those countries. And so at this stage, this is not the end of the story. So these applications can pend before each of the patent offices in the countries in which you filed from anywhere from up to 5 years. And sometimes you get very lucky and you get a first action allowance. And that can occur quite quickly, maybe within 20 months or so. But in those cases, I sometimes view that as a failure, because it just means that we didn't ask for enough. We could have been a lot more aggressive with claiming the invention and asked for more. So we might have left, claim scope on the table. Or other times it means that the claims were properly drafted in view of the prior art, and we got it right from the get-go. But in each of these countries, you'll need to allot money to cover the cost of responding to office actions that are issued by each of the patent offices. So each of these patent offices will examine the application and determine whether or not it satisfies the requirements of patentability. If there are certain deficiencies in the application, say lack of novelty or lack of inventive stuff or obviousness, the patent office will issue an office action or an official action inviting the applicant to respond to remedy the issue. The applicant, working closely with their patent attorney, can prepare a response and file it. And the patent examiner at the patent office will then review the response and determine whether or not that response puts the application in allowance. If not, the patent office will issue another official action, inviting the applicant to respond again. So it's common for, depending on the country, you can expect anywhere between 3 and 4 office actions to issue before the patent application will be granted. In China, oftentimes it's higher. It might be 5 or 6 times the patent office issues office actions. And so anytime an office action is issued, there will be costs incurred. So depending on the complexity of the office action, we're looking at 10,000 Hong Kong dollars to 27,000 Hong Kong dollars, and sometimes even more, to prepare and file a response to that office action. Okay. What's important in this whole entire timeline is that once the PCT or direct national phase applications are filed, you cannot add any new matter. So it's very, very important that we include a detailed description of the invention here, sufficient supporting data to support the patentability of the invention, because after these applications are filed, we may not have an opportunity to submit, to add any new matter. There is an opportunity to file post-filing data to support, for example, the inventiveness of the invention, but our ability to file such post-filing data is limited in certain countries. Okay. So speaking of filing and the costs involved in filing, one question that young companies oftentimes grapple with is where to file. And if budgets were unlimited, companies, it wouldn't be a hard problem. You simply file everywhere. But as you can see on this chart here on the right-hand side, costs just for national phase entry can be extremely high, even when only filing in 9 countries. So this does not take into account the cost of drafting the application or prosecuting the application in the 9 countries, just the cost of filing the application and translation. But we can, the importance of this table here is just to show the law of diminishing returns here. We can capture 93% of the market. These percentiles here, this table is based on a typical pharmaceutical filing. But by filing in 9 countries, you can capture 93% of the market for this particular indication at a cost of $81,000. If you wanted to increase it incrementally from up to 95 to or even to 99,000, we're looking at a substantially larger outlay in the cost of national phase entry. So all of this data is taken from a very, very interesting article that was published in 2005. Unfortunately, I haven't come across more current data, but this should just give you an idea of some of the costs involved in national phase filings and how those costs relate to market coverage. And so back in 2003, the USA for this particular pharmaceutical indication accounted for about 45% of the total world market. And you can see the top 10 descending here. You can see that that's changed quite a bit in this data from 2016. The one thing to note here is that the EPO shown here in aggregate, all 38 countries of the European Patent Office, convention countries, but here they're broken down country by country. But the takeaway from this slide here is that filing patent applications and obtaining patent protection is very expensive. Determining what markets to file in is something that you should be thinking about even before filing your application, so that you ensure that you've set aside the appropriate amount of money to cover the costs for drafting, filing the application, filing national patent applications downstream, and then prosecuting those applications. This slide also shows the costs that can be delayed by filing a PCT application. If you filed a provisional application at month 0, followed by direct national applications at month 12, the company would be hit with all of these costs right away. I mean, you don't have to file in 9 countries. Even if it's in 2 or 3 countries, the costs can still be substantial for a small company, because you're still talking about translations, filing fees, professional fees, etc. By filing a PCT application, you can delay those costs by up to 30 months from the filing date of the provisional filing. And it also provides you with time to do your market surveys, do your business development, identify where your markets are, identify who your partners are going to be, identify where you're going to manufacture the product. And those all of that information will inform where you're going to file your patent application. All right, so we're going to quickly revisit the requirements to obtain a patent. We're not going to touch on subject matter eligibility. This question was raised after Mr. Tan's presentation. This is an important question, particularly in the context of computer implemented inventions like AI software algorithms, but also in inventions relating to natural phenomena like diagnostics. We could probably spend 2 hours talking about that subject alone, but we're not going to cover it here. Industrial applicability is a very low standard to meet, doesn't require much. It's a foregone conclusion for almost any application that we file on, that it will be industrially applicable, i.e. it has some utility, it's good for something. What I want to talk about in the next 2 slides is talking about the data that's required to be included in the application to satisfy the written description requirement, as well as the enablement requirement. The applicant is required to teach the public how to make and use the invention. That's enablement. We'll also touch on novelty and inventive step and see how both of those requirements play a role in crafting the scope of the claims. Okay. All right. So on this slide here, we talk a little bit about the research and data that should go into filing an application. This data doesn't generate itself, and so the success of a patent filing it is oftentimes predetermined months or even years before the filing of the application, based on the data and the research and development done to file the patent application. So in order to satisfy the written description requirement, we have to clearly describe the invention. And we have to teach how to make and use it to satisfy the enablement requirement. And so what this means is that typically in a chemical life science patent application, because we're dealing with an area of technology that has a very high level of unpredictability, the patent application or the patent offices aren't simply going to grant us a patent without proving to them that the invention actually works, right? And so if we're talking about an invention related to a doorknob, based on first principles, a mechanical engineer would know a doorknob would work in a certain fashion. And so this is why what you'll find in many mechanical patent filings and many software-based filings, there is no data. But when looking at chemical life science patent applications, they're loaded with data. They're loaded with exemplary embodiments. And the reason why is without these exemplary embodiments and then without this data, we would be unable to obtain a patent with commercially valuable claim scope, right? So typically, in order to support a genus, and what I've shown here, the white circle here represents graphically the scope of a claim that is filed in an initial patent application. And within the specification, we will include exemplars. Let's say this is, I'm a small molecule chemist, right? So these are each represent a different molecule, and they're described in the specification, but together with the description of the molecule, we also describe their efficacy, let's say against treating cancer, right? And the size of this genus, the size of the genus that's going to be supported is going to be based on the number of exemplars we have. So if we have a broader genus, we need more exemplars, more embodiments to support the scope of that genus, because based on this one example, we wouldn't know whether or not this example over here, far away in chemical space, whether or not they would have the same sort of properties, whether or not it could also be used to treat cancer. So that's why we need to include the data supporting that, right? So it's very helpful to include, supporting data, comparative data, showing, the performance of each of these molecules. Some of these might be duds, right? They have low performance, and other ones may perform extremely well. But it's important that we include all of that data there, because even the low performing examples can be used as a point of comparison to establish the inventiveness of the claimed invention. Experimental protocols should be provided describing how to make and use all of these molecules here. So what I've shown here as well is prior art. So if the claim reads on the prior art, it would mean that the claim lacks novelty. So our white circle here reads on all of these X's. These are all different prior art, except for this one, different prior art disclosures. So the white circle would be deemed to lack novelty. And so if an office action issued rejecting our white claim for lack of novelty in view of these prior art references, we'd have a couple of options available to us. We could either argue with the examiner that they are wrong, but in this case they're right. Let's just assume that they're right. If the examiner is right, we have to amend the claim. And so in order to amend the claim, we need to have support for that claim amendment in the specification as filed. We cannot add those claim amendments or support for those claim amendments later. That would be considered new matter. And so that's why it's very important working together with patent attorneys to craft the claims as well as narrower claims that focus in on preferred embodiments. And so the blue circle here doesn't read on any of the prior art, and so it would be considered to be novel in view of the cited art. But that isn't the end of the story. We also have to establish whether or not this claim here, the blue circle, is inventive, whether or not it's obvious in view of the prior art. So here we're going to talk about data to establish the inventive step or the non-obviousness of the claimed invention. This is referred to as a technical effect, right? And so this technical effect cannot be predicted in view of the prior art. It has to be unexpected. And without doing a very thorough prior art search, we may not know all of the prior art that's available out there, that exists out there. And so this is why it's very, very important to include as much data in the application describing the properties of these molecules in the hopes that that data could potentially be used to establish a technical effect in view of the cited art, right? And so oftentimes, you know, I'll ask clients to include developmental data generated in the course of optimizing the performance of these compounds. What we don't want to see, and I'm sad to say I see this quite often, are examples or invention disclosures where there might be only 2 examples. And from those 2 examples, it's very difficult to predict what the scope of molecules that have the same properties have. So that's why it's really good to have as many examples as possible, right? So we want to avoid one and done, one embodiment invention disclosures. We want to have several embodiments that are described in the application. And this is helpful because it allows us to compare data from less operable embodiments. And so in this example here, the patent examiner may cite this red reference as the closest prior art, and then argue and conclude that in view of this prior art, that the blue circle here lacks an inventive step because it would have been obvious based on the teachings of this prior art, either alone or maybe in combination with other prior art references or general knowledge in the art, to modify this reference to arrive at the claimed invention. So again, we have 2 options here. We can argue that the examiner is wrong, right? Or we can amend the claims. And so what I show here is maybe these 5 examples all possess a property that the examples in this prior art do not, and such property would not have been predicted in view of this prior art. So let's say, for example, these 5 examples have selectivity against their target, a receptor. Maybe they only target the alpha receptor as opposed to the beta receptor, and these prior art references are indiscriminate. They target both alpha and beta. By showing that there is the selectivity and there's a therapeutic effect, maybe these compounds here don't have as much toxicity, right? We can establish the inventive step of these compounds here. And so what we would be left with is this white circle that claims those compounds that are both novel and inventive in view of all of the cited art. And so this is what we'd be left with in this patent application, this claim here. So these embodiments here would be left out, and hopefully these aren't the embodiments of the most commercial interest to the company. If they are, then we have to revise our strategy. And so this is why it's very important to discuss claim amendments that are proposed by either the inventors or the patent attorney carefully to ensure that it covers the commercially relevant embodiments that are being worked on today, and hopefully those that are being worked on tomorrow. So hopefully the most active compound, maybe it falls somewhere here, and that might be the subject of a later filing. But so all of this data here, data to support the written description requirements of obtaining a patent application, data required for establishing an inventive step. This is all data that is going to be generated in the course of doing your development, your research and development. And so the success of a patent filing, like I mentioned, may be determined, 1 year before filing the application. So it's really important that this data is included in the application. What some applicants do is when they file their provisional application, it might be a little bit forward-looking, where they may only have, let's say they only have these examples here, these 3 here. In that provisional filing, we may say, hey, look, we're going to describe some other examples or other subgenuses of examples that will be made and tested over the priority year after the provisional filing. And so if those are described in the provisional application, it's very important that research and development continues to support the patentability of those subgenuses or species that are described in the provisional application. So that gives you a year to generate additional data and file and include it in the PCT filing or the direct national phase filing application 1 year after the filing of the provisional filing. So data is extremely important for chemical life science inventions. So here's an overview of the patent preparation and examination process. I've talked a little bit about this already. This part here, starting from the invention disclosure, actually from the company's perspective, even preparing the invention disclosure, this isn't the beginning of the story. You need to run the experiments to generate the data, to prepare the invention disclosure. Once this is prepared, the patent attorney working closely with the inventors drafts a patent application, teaching how to use and claiming the invention. Because the inventors are the subject matter experts, it's important that the drafting attorney works closely with them. It's also very, very important that the drafting attorney has a similar technical background as the inventors, as where the invention is. So, for example, you don't want a software engineer drafting a patent application to a therapeutic, right? And vice versa. If someone came to me and said, we have a software-based invention, I would tell them, I'm not the guy to draft this for you, but I can refer you to one of my colleagues. So if you're working with an attorney that says they can draft everything, my advice to you is be wary, right? You have to doubt that. So once the draft, the first draft of the application is prepared, there is a revision process, and this will go back and forth until both the inventors and the drafting patent attorney or attorneys are on the same page. Once the patent application is finalized, it is then filed. So this process can take anywhere between 4 and 6 weeks. It can be accelerated if necessary, but the more time allotted to this, the better. You'll have a better work product, which improves your chances of success. So once the patent application is prepared and filed, it can be once it's filed at the National Patent Application our patent office, let's say it's the U.S. Patent Office, an examiner with an appropriate technical background similar to the invention will examine the patent application, conduct a prior art search, and then determine whether or not the claimed invention is patentable in view of the prior art. If it is, and you're lucky or unlucky, you get a notice of allowance, a first action notice of allowance. And so, like I mentioned before, this might mean you didn't ask for enough. So it pays to be greedy here, right? When drafting patent applications, we want to draft them such that the claims, the broadest claims, are novel. If the broadest claims, there's a question about their inventive step, that's something that we can argue with the patent office. Filing an application where novelty is not in doubt, but maybe inventive step is, that's where you want to be. That's sort of the sweet spot of claiming the application. So if the examiner determines that there are some deficiencies in the application, maybe the applicant hasn't taught how to make and use the invention, hasn't described it, maybe it's vague, they use unclear words like trademarks, and you can't use recite a trademark in the claims, for example, or the claimed invention lacks novelty or inventive step, they will issue an office action. They'll issue an office action to the applicant, inviting the applicant to file a response, typically in about 3 months. And oftentimes this can be extended up to 6 months by paying a fee. The applicant reviews the office action with a patent attorney, working together with their inventors. They prepare a response, which is then filed at the patent office. The examiner reviews the response again, determines whether or not the response puts the application in condition for allowance. If not, they'll issue a further office action. At the USPTO, the average pendency is about 24 months until final disposition. Final disposition means either a notice of allowance or a final rejection. If an application is finally rejected, that's not the end of the road. The applicant can file a request for continued examination. The official fee is a little bit high, but it's not uncommon for 1, maybe 2, or even 3 requests for continued examinations to be filed in the course of prosecuting an application. If the patent office gets it right and the applicant agrees with the examiner essentially and the patent attorney that there's nothing there and the chances of obtaining a patent are slim to none, it's best to simply abandon the application to save added costs. So throughout this whole entire process, as you no doubt have determined, inventor technical input is extremely important. And this is why it pays dividends to maintain a good working relationship with the lead inventors or the staff involved in the continued development of the invention. You don't want to create any bad blood with them. So we've talked a lot about obtaining a patent up until now, and now I quickly want to touch on freedom to operate, and this is something that's not really discussed a lot when it comes to commercialization and licensing of inventions, and it doesn't come up that often with my clients, and I raise it because it's an important issue. If there are blocking patents on the markets that you're interested in entering, you will not be able to enter those markets without incurring legal liability. For example, for patent infringement. So freedom to operate is the ability to develop, make, use, sell, offer to sell, import, or market a product and or service without legal liability. And what we're going to talk about here is patent infringement, but there are other liabilities that can be incurred. So for example, breach of contract in a material transfer agreement or a NDA, for example, those might be other legal liabilities that might affect freedom to operate. So as Mr. Tan mentioned in his presentation, obtaining a patent does not assure that the patent holder has freedom to operate. They may be third parties that hold blocking patents that restrict the patent holder's use to practice their own invention. So those third-party patents may be directed, maybe a broad dominating patent that covers the product itself, or possibly the use of the product, or even maybe an intermediate used to prepare the product. So there are a lot of different ways in which patents can block your use of your own invention. So simply, I would imagine that a lot of people in this program are licensing or considering licensing their technology from a Hong Kong-based university or government research institute, but licensing that technology from those entities does not assure FTO. Those entities work on a buyer beware, caveat emptor policy. So it's important that the would-be the startup company do their patent diligence, their freedom to operate diligence to ensure that they have freedom to operate around the licensed technology. What's important to note is that FTO is country specific. So in order to determine your FTO, you need to look at each of the markets of interest. And it may turn out that you have FTO in the United States, but don't have FTO in China, or FTO in Japan, but no FTO in Hong Kong, for example. So it's important to do this on a market by market basis. And also note that FTO is not static. So there are a couple of things that can change. As you develop your product or your service, as it changes, your freedom to operate, the company's freedom to operate with respect to that product or service can change. Right, and so this is something that you need to keep your finger on and continuously monitor the FTO over time. In addition to that, the patent landscape, the patents, the potentially relevant patents in the space where the product or service is continuously going to be changing, right? So there are going to be new patent applications filed, new patents granted. During the course of examination, claim scope can change. So a claim that was a problem before through amendment may not be a problem later, and vice versa. So there are two things that need to be continuously monitored until you reach the market. And even after reaching the market, it's important that these things are continuously monitored. So conducting an FTO search and analysis can be a costly endeavor. You're looking at about 40,000 Hong Kong dollars per country to do an FTO search and analysis, or higher, depending on the complexity of the invention, how many embodiments are going to be searched, etc. When conducting the FTO search, again, it's going to be country specific, and a search will be conducted based on a description of the invention that identifies potentially relevant patents. Once those potentially relevant patents are identified, a review will take place to determine the status of the patent, whether or not it's granted, it's pending, and what risk those granted claims or those pending claims pose on the FTO, the freedom to operate of the product or service. So the risk is then assessed of the pending or granted claims. Some of our clients go even further and look at whether or not there's support in the specification for a potentially relevant claim that would read on the product or service. Because oftentimes competitors may, if their invention is directed at A, space A, but your invention is in space B, if they have support in their specification to enter amendments to amend the claims such that it's focused at space, your space, I forget it was A or B now, excuse me, but at your company's product or service, they will do that if they're particularly litigious, if they want to create additional barriers for entry for the company. So this is something that some clients will look at as well. Once risky patents, patents and pending applications that pose a potential risk are identified, you want to work closely with your inventors to determine whether a workaround is feasible, making changes to the product or service such that they no longer fall within the scope of the pending claims or the granted claims. This is called patent busting or working around. And this is very, very common in the industry. And then you want to continue to monitor relevant pending patent applications to continuously monitor their risk until they grant, and also determine whether or not the applicant of those patents file a continuing application or divisional application, because so long as that patent stays alive, it poses a risk to the company. So what do you do if there is an FTO risk? Work around the claims, as I've already mentioned. You can confine your R&D and commercialization to countries without patent protection. So if there's only patent protection in Europe and the United States, maybe you focus on East Asia or Southeast Asia, depending on what the market is and what the product is. Consider attempting to invalidate the patent. So there's opportunities for third parties to submit observations. This can be done confidentially through a third party, or you can attempt to invalidate it through opposition proceedings, for example, at the European Patent Office, or invalidation proceedings through re-examination in China or the United States. There's also an opportunity to in-license patent rights or partner with the company that owns the patent that's creating the FTO risk. Worst case scenario, there's also an opportunity to infringe to protect the company from a finding of non-infringement, of willful infringement, excuse me, by engaging a U.S. patent law firm to prepare a formal non-infringement opinion. These are very large and costly endeavors. You're looking at between maybe 160 to 320,000 Hong Kong dollars to prepare such an opinion. But it can be used to shield the company from a finding of willful infringement and treble damages, 3 times the actual damages to the patent holder. So that's it from me. I'm not sure if we have time for questions, but I'll leave it there.